because I didn't know this one either.
Okay.
For the purpose of the Family Court Act, the terms support and maintenance are synonymous. The new Article 5B FCA Uniform Interstate Family Court Act replaces the DRL Act, and it says children are entitled to support and is not dependent on the marital status of their parents.
Oh boy.
Okay, next. Parents are chargeable with the support of their children up to blank years of age.
21 years of age.
Child support percentage for one child shall be blank.
Oh my God, I just did these, but I didn't study them, but I'll try to do it off memory. For one child is 15.
17.
17, sorry, I don't know where I came up with 15.
That's funny because that was it. Okay.
17, 25, 29, 32, and 35.
I think it's 31 and 35.
31 and 35. I'll get it. I just, like I said, I could do it, and then until I see it on paper and read it a few times. But that's probably something I'll put in the video to listen to.
Yeah.
Which we are.
Yeah, which we're making right now.
Yeah, I love the way that you cut out all the crap in between.
I know. I try, but sometimes the crap in between actually helps us remember, so.
True.
Okay, this was amended 2015. Combined parental income shall mean A, the income of both parents added together, B, the net income as reported on the most recent federal tax return, C, the average gross income as reported on the last 3 federal tax returns, D, the average net income on the last 3 federal tax returns.
I have no idea. Can you read the answer, the question with the answer as if it's just a statement? Like just read it so that when you record it, I could just hear it all in one sentence?
Yeah, because this
without
one...
without the other choices, you know what I
This
mean?
is different than when we took the test.
Okay, so I don't remember when we took the test, so it doesn't matter.
Oh,
so just
all right.
say it so I can hear it.
Hold on, let me just make sure I'm looking at the right thing here. Okay. Combined parental income shall mean the sum of the, quote, income of both parents, period.
Okay, so you know what? Want me to add that to the bottom of my test?
Yeah, because that is not... I mean, they definitely were talking about the 3 gears and all that crap on the last time.
Okay, what article is this?
This is 413.
413.
I think it looks like sub 1.
That's all right. I'll just put 413. I'm not worried about that.
And then B5 and little I.
Listen, that's okay. I'm not even going to put that. How do you want me to word it? I don't even want to put the fake stuff in. Just let me write and then I'll put true or false. You know what I mean?
Okay. It says combined parental...
Wait, maybe I'm going to put you on the thing voice dictation. So maybe my thing will pick up you saying it and it'll type it out. Let's try it, okay?
Okay.
Okay, when I say go. Go.
Combined parental income shall mean the sum of the income of both parents.
Okay. Next question.
Okay, next. Upon proof by either party that cash medical support would be unjust or inappropriate, the court shall A, order the parties to pay cash medical support as the court finds just and appropriate, B, consider the best interest of the child, C, set forth the pertinent factors, the amount calculated, the reasons for not ordering such amount, and the basis for the amount awarded, or D, follow all or none of the above considerations.
No idea.
Okay.
I don't even remember reading that.
So, yeah, me either. So it's all of them. It's all A, B, and C.
What was the question?
Upon proof by either party that cash medical support would be unjust or inappropriate, the court shall... I'm going to read all with the correct answer.
So what does that mean, cash will be inappropriate?
I don't know.
Wait, read that sentence one more time to me.
Upon proof by either party that cash medical support would be unjust or inappropriate.
But I think it's inappropriate.
But
No.
well, I think this is talking about children because it says consider best interest of child.
Right. Oh, then the kid wouldn't be in the interest of the kid. He wouldn't be with him if he's a drug addict.
Yeah.
So that there goes my theory. It doesn't make sense. What would be unjust or not?
I don't know. Should I go get the book?
Don't bother.
Okay.
Just go to the next question.
All right, next. The court may allocate a portion of which of the following sources of income to child support? 1. Life insurance. 2. Recovery of bad debts.
Wait, I'm going to say no on the life insurance. I'm going to do them as you say, yes or no. No.
Okay. Yeah. Life insurance.
Is no, right?
I think it's a yes.
Oh, fuck. Okay.
Yeah.
All right, I'm going to interrupt you. Read it again and I won't
Okay.
interrupt you.
So let me just make sure that if it's not all of them, I'm gonna take out the wrong answers.
Okay.
So that we're only memorizing the correct answers, and it's
Yeah.
all of them. It's gonna be all of them. Okay, so it's a study question. The court may allocate a portion of the following sources of income to child support: life insurance policies, recovery of bad debts, gifts and inheritances, discharges of indebtedness.
Wow, I'm going to have to remember that.
Yeah, it's a weird one. All right, do you want to ask some of yours?
All right, let's go through mine because mine, a lot of my questions might be just short answers.
Okay, good.
And they're all in order, Okay, 411. The family court has exclusive jurisdiction over proceedings for support or maintenance. True or false?
True.
2. On its own motion, the court may at any time in the proceeding direct the filing of a what?
In Article 10.
Yeah, neglect petition.
Perfect.
Do those two, does 4 and 10 go together like hand in hand?
I don't know. Well, I guess if the parents aren't supporting the kid,
Oh, okay.
if nobody's supporting him, then
Yeah. Okay, number 3. The parents of a child under the age of what years are chargeable for the support of a child?
21.
Right. When I go through the test, I use these questions as like a guide. A
Okay.
parent is responsible to support his child until said child reaches the age of
21.
right. Did shall mean one child equals
17%.
percent. Two children equals
25%.
3 children equals
29%.
4 children equals
31%.
5 children equals,
Not less than 35%.
and that's actually 5 or more children.
Okay, so if it says not less than, that means it could be 35%.
Right.
Okay.
Okay, next question. The term income for purposes of child support shall mean but not limited to. And it's a study question. I'm just going to read them all, okay?
Good.
Workers' compensation, disability benefits, unemployment insurance benefits, Social Security benefits, veterans benefits, pension and retirement benefits, fellowship and stipends, whatever that is, stipends, annuity payments, alimony or maintenance pursuant to an existing order.
All right.
Self-support reserve shall mean
135% of the federal income guidelines for the poverty something.
Oh, you're really so close. It's self-support reserve shall mean 135% of the poverty income guidelines amount for a single person reported by the Federal Department of Health and Human Sources.
Shit. Okay. All right. I think I would recognize that though.
And this is such an obscure amount. For the calendar year of 1989, of all years, why did they pick 1989?
It's like $8,000 or something.
It's $8,065.
Oh my god! I hope they don't do that.
And here's another part of the whole thing that's a little obscure. On what month and day of each year the self-support reserve shall be revised to reflect the annual updating of the poverty income guidelines?
I'm going to guess March 1st.
It is.
Okay.
So let's just go read that real quick again. The three things is 135%, 8,065, and March 1st.
Gotcha.
Okay. Next question. Which of the following shall be deducted from income before the court begins to calculate a parent's basic child support obligation?
FICA taxes actually paid, support paid to another kid, not the child in the petition, and that's the only ones I can remember.
Okay, so the first one is unreimbursed employee business expenses. The next one was the one that you said, alimony or maintenance paid to a spouse not a party to the action.
Okay.
The next one, alimony or maintenance paid to the spouse who is a party to the action.
Right. Okay, this is new since we did it. They finally figured out how to fix it.
Child support actually paid pursuant to court order who is not a subject to the action. What does actually paid mean?
Oh, just like it means like if you're not paying the child support to the other person, I guess.
Oh, okay.
Like just because there's a support order, if there's a support order telling you to pay your kids in California support and you're not paying it, they don't deduct that.
Okay.
I think that's what it means.
Public assistance.
Yeah.
Supplemental security income.
Okay, SSI and public assistance.
Here's another one that's kind of weird. New York City or Yonkers income or earnings tax.
Oh, okay, that makes sense because it's not income because you're paying it back in taxes.
Taxes, but why is it only New York City or Yonkers?
I don't know because all your federal taxes are still included, and I don't know.
That's kind of bizarre. That's something I could see them asking.
Okay, so we got to just remember that. That's
Yonkers, like of everywhere in New York State, they pick Yonkers.
Well, maybe they have really high taxes.
I think Chamunka, New York, or somewhere. I don't know. It's just weird. Yonkers. I don't think Yonkers. I don't know. I think the highest taxes in Long Island are in Nassau County.
Yeah, but there you don't have an income tax in Nassau County. Like I pay a New York City income tax.
Oh.
To live in New York City, so like I pay like $5,000 or $6,000 a year on top of my state taxes in income taxes to the city of New York.
All right, let's just go through them really quick to just define what they are. What's unreimbursed employee business expenses?
That's like if you own a business, I guess, and you're paying, like you have to have a health insurance policy for your employees. That's an expense.
Oh, okay, so business expenses is the key there.
Right, like for your business, you actually have to buy the hair. That's a business expense.
They can't touch my business. Okay. So the other one is alimony
well, they can. They can touch your income from the business, but not your expenses.
Gotcha. Business expenses. Alimony and maintenance paid to a party not of the action. Alimony and maintenance paid to a person who is in the action. Child support, subject not to, of the action. Public assistance. What would you be getting public assistance from?
That's like welfare.
Welfare, they can't touch your welfare. SSI, Social Security, they can't touch that. They can't touch New York or Yonkers income tax aid, and they can't touch the FICA. All right.
Yeah, because the taxes make sense because like you're not even getting the money. You're never seeing it. Yeah.
Right. Section 413-a. Any party in a child support order may request, if the child is in receipt of public assistance or child support enforcement services, may request that the support collection unit review the cost of living adjustment purposes. I got my brain. Cost of living adjustment shall be made by the support collection unit if the sum of the annual average changes of the consumer price index for the urban consumer CPIU as prescribed annually by the United States Department of Labor Bureau or Labor Statistics is 10% or greater. The cost of living adjustment and the adjusted child support obligation amount shall be reflected on the adjusted order issued by the support collection unit and mailed to the parties by first class mail.
All right, good. Let's do the next one. I got it.
Okay. An objection to the cost of living adjustment, as reflected in the adjusted order issued by the support collection unit, may be made to the court by blank or by blank.
An objection, um, the person who's paying it.
It's actually by either party
What? All right.
or by the support collection unit themselves.
What the fuck? Okay.
Yes, that's tricky.
Why would the support collection unit object to
Yes,
it?
I said the same thing when I was making the test. I'm like, this can't be, but it is.
Okay.
So an objection to the cost of living reflected in the adjusted order may be made by either party or the support collection unit themselves.
Oh my god, I can't with this shit.
And the objection to the cost of living adjustment shall be submitted to the court within how many days from the date of the mailing of the adjusted order?
The objection, I think I'm gonna guess, because I don't know. Is it 45 days?
35.
35, alright.
So in other words, if the fucking support collection unit adjusts something, he has 30 days to decide that he wants to make an objection about it.
But I don't, okay, or the...
I'm sorry, I meant 35. Did I say 30? I meant
Yeah, 35. Or the support collection unit could apparently object to their own order.
That's what I'm saying. The support collection unit makes the adjustment, and then within 35 days he says, nah, no one object to that.
Oh my god.
And the objection shall be in writing.
True.
Right, because remember we said a written objection?
Yeah.
And must be made within 35 days from the date of mailing the adjusted order.
True.
Right.
Okay, we could say that's Frank's question.
Okay. I think I did. No, I did.
You did? You did already? Okay.
Yeah, check your email.
Okay, so this one's going to be out of order a little bit. A or a shall here.
Okay.
Okay? And any order of support made by the court may or shall provide for health insurance benefits.
Oh. I'm going to say shall?
Yup.
I just guessed.
That's it, yeah. It shall, so it has to.
Should I put that in the back of my test?
Yeah,
Probably.
maybe, because that's like a weird
That's a
one.
short question. I can add that one.
Yeah.
Okay, hold on. What fits? And then I'll make it like a true or false.
Are you ready for the next one?
Yep, go ahead.
Okay. Who of the following... Oh, I think this is a repeat of your question, but I'll do it anyway.
Okay.
Who of the following may request a review of an order for a cost of living adjustment under Article 4?
Oh, okay.
And it's...
Either party or the presentment agency?
No...
Or the support collection unit. Wait, say the question again?
Yeah, no, you corrected yourself. It was not, the answer is any party to a child support order or
the support collection unit.
yeah, but they're, in this article, for whatever reason, they're calling it a child support enforcement service.
Oh.
But
Okay.
it's the same thing. It's a support collection unit.
Okay.
All right. So the court shall conduct a hearing on a cost of living adjustment objection
Okay.
and make its determination no later than how many days from the date it receives the objection.
I wonder if I had this in my test, if I did this. I'm going to guess and say... Oh, God, nothing is going to ring the bell in my head with number.
Do you want the choices?
Yeah.
45 days, 35 days, 25 days within a reasonable period of time.
Within a reasonable period of time.
And 45 days is the answer.
You know what? It's so funny. I was going to say 45 at first, or then I went to 35 in my head, and then I'm like, maybe it's in a reasonable time. I'm such a... All right, so read me the question again.
With the right answer?
Yeah.
Okay. So the court shall conduct the hearing and make its determination on an objection to a cost of living adjustment no later than how many days from the date it receives the objection?
And that's 45 days.
45 days. Yep.
Wait, the 35 days is if they want to make the objection.
Yes, and the 45
And
days is
45 days, maybe I should add that, like the court has to make the objection within 45 days.
So maybe add next to that question.
In that question, I'll just add it right after that.
And then the court has to have a hearing and make its determination within 45 days.
I'm just gonna wait. Where is it? Let's see. Okay. Yeah. I'm just gonna add that. I'm gonna put right here. Written objection. I'm gonna put right after the written objection, which is 35 days. Right. I'm gonna put it after that.
Yeah. The court has to apparently have a hearing.
I'm gonna put the court. Which I put the court will have a hearing.
Yeah, the court, after the hearing, the court has to issue its determination within 45 days.
What I'm going to put, the court will have a hearing to determine the order of the objection?
The objection, yeah. Like an objection hearing.
The court will have a hearing.
Yeah, we can call it the objection hearing.
Hearing to determine the objection, not determine, what the objection, to make a decision on the objection.
Yeah, they make a determination.
To make a determination on the objection. Within what within or after, what is it?
Within.
It's within. Within 45 days?
Yeah.
Oh man, I gotta add that to my answer sheet now. Question number 9, I gotta add 45 days. Okay. Wow, that's something interesting to know. I didn't get that. I didn't catch that.
You know what? That's why it's good when we both have questions, you know?
Right, totally. Okay. This is just a true or false question. When no objection has been timely raised, so if nobody makes that objection within those 35 days, the cost of living adjustment adjusting a living adjustment and adjusted order, such adjustment shall become final without further review by the court or any judge or magistrate.
I'm going to say true.
Yes.
Okay. All right. This is 424-A subdivision B.
Okay.
And I did not know this. I forgot the answer to this already, so I have to look. Okay. All right, I got it. Just tell me which one is true as I go through them.
Okay.
Upon the failure of a party to provide a completed affidavit of net worth, the support collection unit may review which of the following to initiate proceedings to adjust the child support order. 1. Federal income tax return.
True.
Correct. 2. State income tax return.
True.
Correct. Current paycheck stubs.
Current paid check stubs. Yes.
Yep. Representative paycheck stubs.
Representatives? I'm going to say yes, but I don't know what representative means.
I don't know either, but the answer is true.
Okay.
Okay.
That's it?
Yep, that's it. You go.
Those 4?
Yeah.
Read the 4 to me again in a row. I won't interrupt you just so we have them more clear.
Okay. Federal income tax return. State income tax return. Current paycheck stub. Representative paycheck stub.
Perfect. Thank you.
All right. And I have something else I can read to you about this. It says the support collection unit shall be entitled to tax information from the State Commission of Taxation and Finance pursuant to social service law.
Oh, God. Okay.
Okay. Just something to know.
I'll read one.
Yeah.
16. Health insurance benefits are reasonably accessible if child 3 lives within the geographic area covered by the plan. 2. Lives within 30 minutes of the service provided. 3. Lives within 30 miles of travel time.
30 miles of travel time. True, I guess. I don't know.
True. They're all true.
Okay. We got to start giving each other some false ones.
I know. But
That is true or false. When the petitioner in the first paragraph is unavailable because of his physical or mental condition to file a petition. A guardian ad litem, a committee, conservator, next friend, or other person appointed by the court may file a petition on behalf of dependent relative.
True, I read that.
True, yep.
But I didn't make a question of it, but I did read it.
Okay,
but
good.
That's why I'm thinking it said husband and wife, but I could be wrong. I mean,
No, you're right, you're right. I'm looking at the statute now, and it says husband, wife, child, or relative.
Oh, okay. All right. You want me to go?
Yeah.
Okay. The court, on its own motion or motion of any party, when paternity is contested, shall order the mother, the child, and the alleged father to submit to one or more genetic marker or DNA marker tests. No?
True.
Okay, no, I'm sorry. I heard a noise. I got scared. Yes, that's true, but then I didn't get really into the question yet. To aid in the determination of whether the alleged father is not the father of the child. And then I went into the question, and it's a 2011 question. Where paternity is contested, the court may order a DNA test on motion of who? A, the court, B, the petitioner, C, the respondent.
I'm going to say the petitioner or respondent.
It's all three.
Okay.
Okay, so the court, the petitioner, or the respondent can make a motion to get a DNA test.
Okay.
Okay?
All right.
No such DNA test shall be ordered upon a written finding by the court that...
I know these from work.
Okay. It's not in the best... But let's get them on the video so we can...
Yeah, okay. It's not in the best interest of the child based on equitable estoppel, presumption of the legitimacy of a child born to a married woman. There's 3 of them. What the hell's the third one? Fuck, I don't remember the other one.
Res judicata.
Yes! Oh my god.
Okay, so what does res judicata mean?
That means another judge already said, you're the father.
Oh, so let me put that in parentheses.
It means the issue's already been adjudicated.
Oh.
It's like a Latin phrase.
I'm going to put that issue's already been adjudicated. Then here's a 2011 question. If the court finds that a DNA test is not in the best interest of the child on the basis of res judicata, equitable estoppel, or the presumption of the legitimacy of a child born out to a married woman, it shall not order such tests, even if requested by the man who is denying paternity.
That's true.
Yep.
Yeah.
Okay. If the record or report of the results of the DNA test indicate at least what percentage probability of paternity...
95. 95.
What'd you say?
95.
Right.
Alright, you want me to go?
Yeah.
Okay. This is out of order, so I apologize.
That's okay.
The court, upon a violation of support order, 1, may enter a money judgment, shall require respondent to post an undertaking.
May.
Yep, that's a may.
The only shall one was the first one, and I only know this because I just made a question on it.
Okay, yeah. So when I said may enter a judgment, money judgment, that was wrong. It has to be shall.
Right.
Enter money judgment.
Right.
Okay, you're up.
Okay. 421, proceedings to compel support may be originated in the blank in which one of the parties resides or is domiciled at the time of the filing of the petition. Upon application, the family court may change the place of trial of the proceeding in accordance with the CPLR.
Okay,
To compel support may be originated in the...
county where one of the parties resides?
Right.
Okay. This is FCA 424-A. Included in the sworn statement of net worth shall be a list of assets transferred during what period preceding the date of the sworn statement?
Preceding the date. The date of separation, the date they separated. I don't know.
Oh wait, no, I have choices.
Oh.
A is 1 year, B 3 years, C 4 years, D 5 years.
Is it 3 years?
3 years.
It's 3. Yep, I just did a question on this.
Okay, good.
But read it again because I was confused what the question is.
Yeah, I mean, I'm a little confused with this question to be.
I wrote the question. I think I understood it better. When I get to it, I might understand it better.
Okay. Okay. Let me try to make it into a sentence and not a question.
What article is this? I'll go try to find my question on it.
All right. It's 424-A.
Oh, I don't have that. Read the question again.
I'm gonna try to make a sentence out of it.
Okay.
The sworn statement of net worth shall include a list of assets transferred during the 3-year period preceding the date of the sworn statement.
Oh, I didn't make a question on this.
Okay, so it's 3 years.
But there is another question that has a 3-year time period.
Oh, good. Okay.
Yep, because that's where I got the 3 years from.
Okay, you go
It
next.
wasn't that question. Okay, next question. This is the question that you just did. Who may originate a support proceeding to compel a person chargeable with the support to support the petitioner as required by law? A husband, a wife, a child, a relative in need of public assistance or care, social service official, and the commissioner of mental health.
Oh, I didn't know about that. The Commissioner of Mental Health?
Yes.
Oh, shit. I didn't know that.
Yep, you want me to read them again and put it on the...
No, can you read it as the Commissioner of Mental Health is also able to, something like that?
Okay, so the Commissioner of Mental Health is authorized by Article 34 of the Mental Hygiene Law to originate a support proceeding.
Beautiful. Okay. Next.
And also, Social Services official authorized by 102 Social Services Law is authorized to originate a support proceeding.
Good. Okay. This is 424-A.
Okay.
A sworn statement of net worth shall be filed with the clerk on a date fixed by court no later than how many days after return date of the petition?
Oh my God. 20? I don't know.
10 days.
Fuck, I didn't even know that.
Okay, so let me just say it again so we get it. A sworn statement of net worth shall be filed with the clerk on a date fixed by court no later than 10 days after the return date of the petition.
Okay, so basically they come into court on the return date, and the judge says, I want to know how much you make.
Well, the support magistrate, but yeah.
Right, he says, I want to know, you got 10 days.
To fill out this form.
From this day.
Yes.
You got 10 days to what? To report back your net worth?
Yeah, and they're measuring it. That was a good catch because they're measuring it from the return date of the petition.
Right. So that's basically, I'm picturing a scenario where the husband and wife are fighting, and she's like, he's lying, he owes me more money, he has another business, and he makes this money. And the judge says, you got 10 days to report back what you make.
Yep.
Okay.
Okay, you want to go next?
Sure. If an agreement for the support of the petitioner is brought about, it must be reduced to writing and submitted to the family court or magistrate appointed for approval. If the court or the support magistrate approves it, the court, without further hearing, may thereupon enter an order for the support of the petitioner by the respondent in accordance with the agreement, which shall be binding upon the respondent and shall in all respects be a blank order, as though made after process has been issued out of the court shall show that such order was made upon agreement. What kind of order is that?
Oh, I don't know.
Well, it's just the word is valid, a valid order.
Oh, okay.
So in other words, if the parties stipulate amongst themselves and the court magistrate approves it, it's a valid order.
Oh, God. Okay. All right,
Because
so
they probably say it's something else order.
oh, I know. All right, so listen, I have another question. This is going to be like A, B, C, and one could be correct. So just
Okay.
we'll
So you
just
want
go
me
through
to
them.
true or false as you go through it?
Yeah, good idea. Okay. A local probation service may provide services to a person seeking to modify an order of support.
Oh my God, I just did a question on this. I can't remember. I'm going to say true.
That's true.
Okay.
The probation service may not prevent a person from filing a petition.
True.
That's true. The probation service may require a person to appear at a conference.
True.
False.
Oh.
It says
What?
right out of the statute, it says the probation service may not compel any person to appear at any conference, produce any papers, or visit any place.
Oh man, I might have made a question on this too because it sounded familiar.
Yeah.
I read it or made a question. We'll come up to it if it's on my test.
Okay.
You want me to go on?
Yeah, you could go.
Okay. This should probably be upon the filing, not on the filing. Hold on. This is why I'm glad I'm doing it because I catch little typos.
Yeah.
Upon the filing of the petition for support, the court may cause a copy of the petition and summons to be served, requiring the respondent to blank. Why the order of support? Yeah. Sorry. To blank why the order of support and other relief prayed for by the petition should not be made.
Show cause.
Yes. The summons shall contain or have attached to it a notice stating, and I'm going to give you A, B, C, and D, and tell me if this is what should be on it.
Okay.
Stating that the respondent's failure to appear shall result in the entry of an order of default.
That's true.
B, that the respondent must provide the court with proof of his income and assets.
I'm going to say that's true.
Yes. C, that a temporary or permanent order of support will be made on the return date of the summons.
That's true.
Yes. D, that a respondent's failure to appear may result in, that a respondent's failure to appear must or may result in the suspension of his driving privileges.
That's a may.
All right, I tried to trick you on that. Okay, that was it.
Okay, so I have 427 A through C.
Oh my God, I have that question right in front of me, I think.
Oh, how funny. Okay.
Question in my test. 427.
Personal service of the summons and petition may be made to the person summoned at least how many days before the time for appearance?
Oh my God, I think it's 8.
Yep.
You know, 8 days is the only one in family court. Is this article? Is Article 4? Is service?
Yeah.
The service in Article 3 is 24 hours. Remember?
Yeah, it's 24 hours. So this one is 8 days.
And service in Article 8 is 24 hours, and service in Article 10 is 24 hours. Service in Article 6 is 20 days.
427 question.
Oh, go ahead. I probably have the answer.
Okay. Under Article 4, which of the following methods of service requires an order of the court?
Oh, I don't know this one.
Okay. So here's the choices. Service upon a person of suitable age and discretion. B, substituted service. C, service by mail alone.
Yes?
No. It
You don't
says
need a court order for that?
it says it does not require an order of the court. The last one is service by publication.
Yeah.
And it says, okay, so the reason that it's not service by publication is because in this Article 4, you cannot serve by publication.
Oh, you can't put that in the public. You can't
You
make that.
can't.
It's like a private thing.
Yeah, you cannot do it. So the only one that you have to have a court order for is this substituted service.
Substitute service?
So yeah, so the service by mail alone,
Okay. So if I could just remember the only one that you need a court order is substitute service, I can remember it that way. So
Yeah.
the mail alone, you don't need a court order.
That's what it says. It says mail alone, you do not need a court order.
Wow.
You
That's
have
a
to.
tricky question
Yeah,
right there.
it is. It definitely is.
All right, good one, man.
Okay.
A proof of service shall identify 4 things.
The person
In a
served.
suitable age of discretion. Yeah.
The
what 4
person.
things?
The person served.
Right.
The paper served.
No.
No?
Person of suitable age and discretion, date, time, and place of service.
So it just could say I served him with a napkin.
Yeah, unless I missed it, but go back and look.
No, I believe you. I believe you. That's just so dumb.
I know, but you should check me just in case all the time, because I think I do a good job, but sometimes I rush.
Okay, so what section is that?
427.
All right, let me just look real quick. I'm sure you got it.
Right after it says, personal service of a summons and petition may be made by delivering a true copy to a person summoned at least 8 days before the time stated for appearance, or delivery of a true copy to a person of suitable age and discretion at a place of business, dwelling, place or usual place of abode of the person to be served, and mailing a true copy to the person to be served at the last known residence at least 8 days before the time stated in the summons for appearance. Proof of service shall identify person of suitable age and discretion, date, time, place of service.
You are right. It does not even say what the papers were served.
So that could be a tricky question.
Oh my God, yeah. It just
Right.
says the proof of service shall identify the person of suitable age and discretion, state the date, time, and place of service.
Yep. And it has to be done 8 days. It has to be mailed and done 8 days before the same time frame.
Now, obviously, yeah, in reality, it would have to say the paper served, but whatever.
Right. In a support for, this is a 2011 question, okay?
Okay.
It's the same question, it's just written differently. Directing the respondent to be arrested and brought before the court when a petition is presented to the court and it appears that A, the summons cannot be served. B, the respondent has failed to obey a summons. C, the respondent is likely to leave jurisdiction. D, a summons in the court's opinion would be ineffectual. E, the safety of the petitioner is endangered. F, a respondent on bail or on parole has failed to appear.
Okay, so I have bad news. I wasn't recording when we did those other questions, so I just want to go back to that weird one. Okay,
Which
so
one?
This is the one in 429.
Okay, go ahead. You do it. I'm going to listen.
Okay, the court may... I'm just going to read it with the right answers.
Yes.
The court may direct a notice of sequestration of respondent's property when it appears that 1, the respondent is not within the state. 2, respondent is about to leave the state. 3, respondent is concealing himself in order to avoid personal service of the summons. Okay, then I have a certificate of warrant expires 90 days after the date of issue. Then I'm going to read this thing in 427 about the service.
Okay.
The following methods of service of a summons under FCA Article 4 require a court order, and the answer is substituted service, because service by publication is not available under this article. Service by mail alone does not require a court order. Note that in substituted service in a civil action does not require court order, but only due diligence could not be proving that due diligence was made. Here, only a reasonable effort at personal service is required. Substituted service of a summons under the FCA in all instances requires an order of the court. Service by publication is not available under this article.
Perfect.
Okay, and then hold on, I have more to go with this. Personal service requires at least 8 days notice. Other options of service are available. Service on a person of suitable age and discretion is available. Service may be effected by mail alone at least 8 days before the time stated in the summons for appearance. And I'm trying to remember if we missed any other ones. Oh wait, the 10 days. I got to do that one. Under the compulsory financial disclosure section of Article 4, a sworn statement of net worth shall be filed with the clerk on a date fixed by the court no later than 10 days after the return date of the petition. Included in the statement of net worth shall be a list of assets transferred during the 3-year period preceding the date of the sworn statement. All right, I think that's all of them that we missed.
Perfect.
Okay.
I'm letting you put that was perfect.
Okay, yeah, I'm so pissed I wasn't recording for all that. Oh my god.
No, but that's all right. But you know what? Sometimes, you gotta speak a little slower.
Oh, I'm sorry.
No, it's okay for me because I'm following along with you while you're doing it.
But when we're in the car driving, we're not going to know what
But
the hell I'm talking about.
yeah, just a little bit slow. But I know you were doing that extra fast because you were mad that you didn't record it first.
You got it.
Yeah,
all right.
You just didn't get it over with.
So you want me to do one more?
Yeah, go ahead.
All right. This is in FCA 433, and it's talking about a hearing when a respondent is brought before the court on a warrant. Okay. And
I did a question on this, so hopefully I know it.
Okay, it says the respondent shall be informed of the contents of the petition.
Yes.
The respondent may present witnesses.
Yes.
The respondent shall be advised as to his right to counsel.
Yes.
The court may exclude the public from the courtroom.
Yes.
Yep.
Did a question on that.
Okay. All right. Do you want to go?
Sure. When a respondent is taken into custody pursuant to a warrant issued by a family court in New York City, pursuant to a support warrant for support.
Okay.
If the respondent is taken, now this says if the respondent is taken into custody in New York City, he shall be taken before who? He shall be taken before the court issuing the warrant.
Oh, okay.
But if the respondent is taken into custody in a county not in New York City, he shall be taken where?
I don't know.
The answer is a family court judge in the county.
Oh my god.
A family court judge in, is it the county or a county?
I don't know.
Let me go look at it. It's 431. Can you go look at that? 431?
Yeah, let me look. Hold on.
It's the family court judge in up county or the county? I didn't do my answer key yet, so.
I need a fucking new book.
431. You ready?
Yeah.
When a respondent is taken into custody pursuant to a warrant issued by a family court in New York City, he shall be taken before the court issuing the warrant. If the respondent is taken into custody not within New York City, he shall be taken before a family judge in that county.
Okay.
In that county. In that. Put that in my answer key. That word is key.
Yeah, in that county.
So if he's taken, so in other words, if he's taken into custody in any other county outside of New York City, whatever county he's taken to, that's where they take him to a family judge.
It's wherever he's in custody.
Right, that's where they take him to a family judge, not a magistrate.
Yup, family. Okay.
It says wait, what was that? 431.
Yeah, so it's a weird one.
It said a family judge. It doesn't even say family court judge. It says family judge. It doesn't even say court.
A family judge?
I'm going to take court out of my answer key because it doesn't say court in the book. It just says family judge that in that court, in that county.
Oh my god, okay.
All right. So we got that?
Yeah. So do you want, can you do one more because I want to brush my teeth real quick?
Sure. Are you recording?
Yeah.
Okay. The court before whom the respondent is taken, start that again. 432. The court before whom the respondent is taken pursuant to a warrant may require of what to appear or in default thereof may place the respondent in custody until the hearing commences.
May require,
Yes, and I didn't know this.
is it an undertaking?
Yes.
Oh, I just guessed. I
Okay.
totally just...
Upon the return of the summons, or when a respondent is brought before the court pursuant to a warrant, the court shall proceed to hear and determine the case. The respondent shall be informed of the contents of the petition, advised of the rights to counsel, given an opportunity to be heard, and to present witnesses. The court may exclude the public from the courtroom in a proper case.
Oh my God, do you know?
It's all of them. He shall be informed of the contents of the petition. He shall be informed of his rights to counsel. He shall be given an opportunity to be heard. He shall be able to present witnesses.
Okay, so now I have a question for you. So this is, the court may permit a party or witness to be deposed or testify by telephone, audio-visual means, or other electronic means at a designated family court or other location, and just tell me when they're true.
Oh, I just read this, but I didn't make a question.
Okay, so I'll do my question. Where such party or witness resides in a county other than where the family case is pending, and that of any contiguous county.
I don't know what answer are you looking for.
I'm looking for, is that right or not?
Yes.
Okay, for the purpose of this section, the counties of New York City shall be treated as 5 separate counties.
You know what? When I read this, I couldn't even deal with it. It shall be dealt with 5. It shall be 5 different counties.
I'm asking, is that true or false?
Yes, because I read that.
That's false.
Oh, I thought I read that.
The 5 counties of New York City shall be treated as 1 county.
Oh, you tricked me.
Okay.
Because I know I read something about 5 counties.
Yeah, okay, that's why I did it. Next, where such party or witness is incarcerated and is not expected to be released within a reasonable period of time.
Yes.
Yep. And where the court determines it would be an undue hardship for the person to appear.
Yes.
True.
See, I remember vaguely reading this, but I don't think I made a question on it, but I'll know when I get closer down the road.
Yeah, just remember the thing about the New York City, it's treated as 1 county.
Yeah, as 1.
Yeah.
Okay.
Okay, you want to go?
Yes. That last question that I just did about shall be informed of the content at the return of the summons or the warrant, the respondent shall be informed of the contents of the petitions and all that other stuff. It says, if I didn't finish reading the rest of the question, if the initial return of the summons and warrant is before a judge of the court, when support is an issue, the judge must make an immediate order, either temporary or permanent, with regard to support. It has to do with, in any support proceeding, the court may permit a party or witness to be deposed or testify by telephone, audiovisual means, or other electronic means at a designated family court or other location. And it's where such party or witness resides in a county other than that of the family court where the case is pending. B, where such party or witness is presently incarcerated.
Oh, so this one didn't have the thing about the contiguous county.
Right.
Okay.
And C, where court determines that would be undue hardship for such party to testify, would be deposed at the family court where case is pending.
All right, so this is similar to the one I did, though.
Yeah, no, but that one you didn't have incarcerated in it, did it?
Yeah, it did.
Oh, I missed it.
Yeah,
Okay.
it said incarcerated, but it said the thing about the counties in New York City, and you know what? I can tell you where that one was. That was in 433, I think.
All right, let's just move on.
Okay, with the one you just did, where was that?
That was in 433 little c.
Yeah, that's the same one I did. The court shall or may make a temporary order for child support pending a final disposition in an amount blank. So there's two questions. I want to know shall or may.
I read this.
Okay.
Okay, so what's the first part of the question?
The court shall or may make an order for temporary child support pending.
That's a shall.
That's a sheer right. In an amount sufficient to blank.
Amount sufficient to, don't tell me. Can you give me choices? Because I might get it if you give me choices.
Okay. Oh yeah, I could give you like three choices.
I just made a question on this.
Based on the income and assets of the respondent, upon a showing of immediate or emergency need, or in an amount sufficient to meet the needs of the child.
Oh God. Say them one more time.
Okay. Based on the income and assets of the respondent. 2, upon a showing of immediate or emergency need. Or 3, in an amount sufficient to meet the child's needs.
I say 2 and 3.
Okay, it's only 3.
Oh shit.
Okay.
What's 3?
3 is the amount. The sentence just by itself is the court shall make an order for temporary support for the child pending a final determination in an amount sufficient to meet the needs of the child without a showing of immediate or emergency need. The court shall make this order notwithstanding that the respondent's income and assets information is not available. And then it just goes on to say that where the information is available, the court may make an order of support based on the formula for child support.
All right. 435. This has to do with reports prepared by the probation service in child support proceedings for use by the court at any time prior to the making of an order of disposition. Are you ready?
Yeah, go.
Okay. This is to do with reports prepared by the probation service in child support proceedings for use by the court at any time prior to the making of an order of disposition. They shall be deemed confidential information furnished to the court, which the court in proper case may, in its discretion, withhold from or disclose, in whole or in part to A, the support magistrate, B, the child's attorney, C, counsel, D, party in interest, E, other appropriate person.
Oh, I have no idea. I don't even remember reading this one. I don't remember. I'm going to say it's most of them.
It's all of them.
It's all of them? Any party?
The thing that's tricky about that one is C, counsel, it says. Who's the counsel?
Well, I thought the tricky one was any party in interest. What the hell does that mean?
Any appropriate person. Okay, so this has to do with the probation reports are given to the court for the court to use for their own benefit prior to making an order of disposition. And those reports are confidential. And the information in them is confidential, and the court, in its discretion, may withhold or disclose, in whole or in part, the probation information in this report to those people. The support magistrate, the support magistrate, that's another weird one, right?
Yeah, like, why would the court have to... I mean, wouldn't the support magistrate just get it?
I don't know, but it says the support magistrate, the child's attorney, the counsel, party in interest, and other appropriate person.
So weird. Okay. All right.
So it says such reports may not be made available to the court prior to the determination that the respondent is liable under this article for support of the petitioner. So they cannot give the court the reports until the court, it says that the respondent is liable to the petitioner.
What the hell? Okay.
It says such reports may not be made available to the court prior to the determination that the respondent is liable under this article for support of the petitioner.
Oh my God, this is the first one I feel like we need a star next to it.
I can't start it yet because I haven't printed it.
Oh, it's all right.
But we're going to be doing these over and over again. So
I know.
We'll go back to it.
Okay.
And then, FYI, the next question I'm going to read is a 2011 question, which you should know because it's the same question.
Okay, let
So
me.
what I just read, well, I don't know, but let me read it how you know who wrote it. Reports prepared by probation service in support proceedings, and then you have to tell me if it's true or false. Okay?
Okay.
Reports shall be deemed confidential information prior to the making of an order of disposition.
True.
Right. 2. Reports may not be made available to the court prior to a determination that the respondent in the child support proceeding. Prior to the determination that the respondent in a child support proceeding. Oh, I didn't finish writing that. It doesn't sound right. Prior to the determination that. I must have messed that up. I'm going to have to go back and redo that. Do you want me to try to find it right now?
No, just remember we got to do Frank's question number.
You know what it is. The court, it says, reports may not be made, let me look at my question. Reports may not be made available to the court prior to the determination that the respondent is liable. That's what I forgot. To the word liable.
Okay.
That's what I forgot.
All right. Do you know this was Frank's question? So do you know what test and number it's on? Because I think I have.
It's on test number 1.
Okay.
I can tell you a question. Do you want the question?
Just tell me what number is.
What number it is? What article is this? 435. Hold on. Question number 435. 49. Okay,
this is from 439. The final order of determination by a support magistrate shall be entered and transmitted to the parties. Specific written objections may be filed by either party within how many days after receipt of the order in court. So this is different than the support collection unit thing, because they're getting the copy of the order handed to them in court. 30
what is the order for? Say it again.
Support order.
And who's serving the support order? Who's making what's going on? I'm sorry. Do it one more time.
Okay, so the support magistrate makes his order in court.
A support order, okay.
They hand the orders out in court. How many days do the parties have to file written objections?
An objection?
Yeah.
I'm making a total guess because I didn't even know this. 15?
30 days, I think it is.
Fuck, I was going to say 31st. Fuck.
Wait a minute, let me just make sure.
Okay.
Yeah, it's 30 days.
Can I put this on my test?
No, because it'll be on mine, so we'll go over it again.
Okay,
and then I have another question. The party on whom written objections are served shall have blank days to file a written rebuttal.
Okay, so they have 30 days to make that they have an objection to the support order.
Yeah.
And then the other side.
No, I'm telling you, it is a stupid time rule that if you did not read this, you're never going to get it.
So the other side now can rebut to his objection?
Yeah.
Okay, so you've got 30 days. I say, I'm going to make, okay, since you said it's such a crazy time rule, I'm going to say he has 45 days from the date the order was given out.
You're going to die when you hear this.
What?
It's 13.
13 days? Fucking what?
Yes.
13 days from what? From the time he puts his objection in?
From the party, it says the party upon whom objections are served shall have 13 days to file a written rebuttal.
Oh my good Lord. All right, next question. So
I gotta put a star next to that one.
30 and 13. I think I should make a question on that one, but that's all right.
Oh my God.
So, my question is 437. A respondent is blank presumed in a hearing in support to have sufficient means to support his or her spouse and children under the age of what? A respondent is blank presumed.
Is I don't know, conclusively, automatically.
Prima facie.
Oh, that thing? Okay. I don't know what that means,
To
but
have sufficient means to support his or her spouse and children under the age of what?
21.
Right.
Okay. Support magistrate, this is 439 sub F. Support magistrates shall be appointed by the blank on a full-time basis for a term of how many years?
Is it the chief administrator?
It's the fucking chief administrator.
Okay, for how many years?
Yeah.
Oh, shit. 1 year?
Do you want the choices?
Yeah, I don't know. Just tell me.
It's 5 years.
5, so support magistrates equal 5 years?
And then, wait, there's another thing about them. Support magistrates shall be attorneys admitted to practice law in the state of New York for how many years?
3 years?
Yep.
Oh, I don't know. I think I remembered that from 8 years ago.
Oh my God, okay.
So it's 5 years is the support magistrate can be a term?
Yeah, it's a 5-year term, but they have to be practicing, they have to be admitted
At
to
least
practice
3
law
years
3
before
years.
they can have a term.
Yes.
Okay, so, you know what? I am just going to add that at the bottom of my thing because that's an easy question to add.
Yes.
So I'm going to put question number 43. Support magistrates. Is that what they're called?
Support magistrates, yeah.
Term equals, and I'm just going to put a dash and then put equals.
Oh my God, this one, I don't remember this next question at all. Maybe you'll get it. It's 456.
Wait, before you go on, support magistrates must be attorneys for at least 3 years?
Yeah.
Must be attorneys. That's easy, right?
Yeah.
Okay, go ahead.
Oh my God, this one is crazy. The period of probation under Article 4, A, shall be for a period not to exceed 2 years. B, shall be for a period not to exceed 1 year. B, no probation is authorized under Article 4. That was C, sorry. And D, may continue as long as there is an order of support in effect.
No idea.
Me either. I have no fucking clue. I don't even remember reading this one, and I made a question on it.
Oh my God.
I don't even remember reading this.
This expires August 31st, 2019. The blank of the courts shall provide in accordance with for appointment of sufficient number of support magistrates to hear and determine support proceedings.
I'm gonna guess the fucking chief administrator because it's usually him.
Yes.
Okay.
And then it says, this one is, there's 2 things in the book where it says support magistrates shall be empowered to, and then support magistrates shall have the authority to. The ones that say they shall be empowered to, I'm going to just read them to you, and they just, I don't know. It's just bizarre. I don't know. You just tell me if you want to answer. It says support magistrates shall be empowered to hear, determine, and grant any relief within the powers of the court in any proceeding under Article 4, support in the Family Court Act. Article 5, which is paternity in the Family Court Act. Article 5A, which I don't know what that is. Article 5B, which I don't know what that is in the Family Court Act. Section 234 of the Family Court Act.
5B, that's the Interstate Family Support Act.
Wait, let me put that in here then. Interstate or intrastate?
Interstate.
Interstate what? Family?
Yes, Family Support Act, like the Uniform Family Support Act.
Support Act, okay. Okay. 5A, I don't know what that is.
I don't know what that one is either.
Section 234 of the Family Court Act. What the fuck is Section 234?
I have no clue.
And Section 235 of the Family Court Act.
Oh my God, I don't know what that one is either.
And the last one is objections raised pursuant to 5241 of the CPLR. Which I don't know what 5241 of the CPLR.
That is enforcement of support orders, of money judgments.
Okay, so let me put that for enforcement of money judgment?
Yeah.
Of money judgment. Okay, so basically, support magistrates shall be empowered, whatever empowered means, to hear, determine, and grant any relief within the powers of the court in any proceeding under Article 4, which is support, 5, which is paternity, 5A, which we don't know, 5B, which is interstate family support, Section 234, Section 235, we don't know, and objections raised pursuant to enforcement of money judgments.
Yes.
And then it goes on to say, support magistrates shall not be empowered to hear and determine and grant relief with respect to an issue specified in, and it gives 5 of them. 455 of the Family Court Act. What's 455 of the Family Court Act?
455. All right, let me. Oh wait, I'll go look on my phone. Hold on.
Yeah, I'm gonna put it in my phone too. Let's see what comes up.
Oh, it says commitment.
Commitment?
This is if he goes to jail. Yeah, it says that's what the title of the article is, commitment.
In issues contested, paternity involving claims of equitable estoppel.
Okay, that makes sense. That has to go to a judge.
They are also not empowered for custody.
Okay, that makes sense. That has to go to a judge.
They are not empowered for visitation, including visitation as a defense.
Okay, so all that has to go to a judge.
And they are not empowered to do orders of protection or exclusive possessions of homes, which shall be referred to a judge.
Okay, so that's an important list. And what section is that in?
That is in section 439.
All right, so I'm going to see if I have any notes on that or a question on it. Oh, yeah, okay, I have a question too, so we'll do both of them.
What's your question?
My question is, support magistrates, A, shall not be empowered to hear and determine matters of custody, shall not be empowered to hear and determine matters of visitation, shall have the authority to make a determination that any person before the support magistrate is in violation of an order of the court, are not empowered to hear a matter of contested paternity involving claim of equitable estoppel.
Is that true?
Yep. That's all the things you just read. We had the exact same question.
Okay. The one of them that you said.
Oh, wait, I'm sorry, I missed one. I have one more. They are empowered to hear and determine all matters relating to support proceeding, including making an order of filiation, and there's a DNA test ordered.
Oh, that's funny because my next question says, where an order of blank and its affiliation is issued by a judge in a paternity proceeding, the child support the child support is an issue. The judge or support magistrate, upon referral of the judge, shall be authorized to immediately make a temporary or final order of support.
Okay.
What's affiliation?
That's who the father is.
Oh, okay. Next.
All right, you want me to go next?
Well, do you want me to do the list of what they have authority to do now?
Yeah.
So that was what they are empowered to do. But if the question has the word authority, it's a completely different list.
Yeah.
They're empowered and they're given the articles. Now, with the authority, it's a little bit more specific. They have the authority to hear and decide motions. So this is more what they can do in the article, right?
Yeah, so this is good. So just read them all the correct answers.
Yeah, so they have the authority to hear and decide motions. They have the authority to issue summonses and subpoenas to produce persons. They have the authority to hear and decide proceedings and issue any order authorized by CPLR 5241, which has to do with enforcement of a money judgment.
For a support order only.
For a support order. I lost here it is. They have the authority to issue subpoenas to produce prisoners. They have the authority to make a determination that any person before the support magistrate is in violation of an order of the court. I think that's the list you read before.
Oh, is it? I don't know. My computer literally just fell over.
I think that, because you said the word violation.
Oh, okay.
So that's why I think you had to make a distinction between the word authority or maybe you said authority. I don't know.
I don't remember what the hell I said. I just know that I remember reading that they can't do those things about contested paternity. They can't make a custody and visitation order, including visitation as defense. They could just basically order due support, and they
Okay.
could, but they could do a order affiliation.
Well, we have to remember this authority list.
Yeah. Oh my
'Cause
god.
this is what they can do.
That's what they can do.
Yeah, let me make a video of. Did you record me saying it?
Yes, I did.
Okay. Ready? I'm going to do the next one. If
Yeah.
the allegations of a petition in a support proceeding are not established by blank, the court shall dismiss the petition. It's a standard of proof, I'm guessing.
Preponderance.
No, you're gonna die because it's not something like that. It's
Competent
something.
proof.
Yes.
Okay, I just guessed.
What the fuck is competent?
I don't
proof?
know, but it was on Frank's test for another question.
Okay. And then
So
it says if a neglect petition was filed in the support proceeding, the court retains jurisdiction over the neglect proceeding, whether or not it dismisses the support petition.
oh my gosh. Okay. All
Okay,
right.
true or false? The duration of a temporary order of protection shall not by itself be a factor in determining the length or issuance of any final order of protection.
I'm gonna go with true.
Yes. Do you want me to go on, or do you want to go on?
Oh, I'm gonna go. I'm gonna do one. I think this is one of the. I don't know if this is from 2011 or if this is earlier because,
Okay.
but it's one of Frank's questions, and this is a support magistrate may suspend a professional or driving privileges of the respondent upon a failure to pay support. This remedy is available when the respondent falls blank behind in arrears. And I'm looking for a time period.
I know it, because I just did a question. It's 4 months.
Yep.
I have a question coming up about that.
Okay.
You want me to go on?
Yeah.
Any order of spousal support made pursuant to this article shall be effective as the date of what? Any order of spousal support shall be effective as the date of what?
When the application was made.
The filing of the petition. And any order of child support made pursuant to this article shall be effective as early of the date of what?
The need for support came up or something.
Of the filing of the petition, or if the children for whom support is sought are in receipt of public assistance, the date of what?
The date they started receiving the public assistance.
Yes, the eligibility, the date of eligibility for public assistance was effective.
Ooh.
Yeah. So
Ooh.
in both instances, it's from the date of filing the petition, but if the kid's getting assistance, it's from the day he's getting the assistance. Okay?
Ooh, yeah.
Okay, so order of support, order of spousal support, order of child support shall be effective. So if they go through the whole case and the case lasts 4 months and he gets child support, they're going to backdate it right from the date the petition was filed.
Ah.
Is that what that's saying?
I think so, yeah.
It says any order of spousal
Because you know
support.
why? Because they're getting it back from, and in the other one where the public assistance thing, that's them trying to get their their money back from the government is trying to get its money back.
Yep. So spousal support order shall be effective as the date of filing the petition. Child support order shall be effective as of the earlier of the date of the filing of the petition, or if the child has public assistance from the date he started to receive public assistance, his eligibility.
Oh, okay. Let me ask you a question because I don't remember this. This is not a test question. It's just I don't remember the answer. Can a support magistrate issue an order of protection?
Oh, fuck. Yes?
I don't remember.
I don't know.
That list that you did about what he can do, was it on there?
No, it wasn't on there.
It
So I
wasn't
would
on
say
it.
no then.
So I would say no too if it wasn't on there.
Yeah. Good question, man.
I got
Next
another
question.
one for you.
All right, yeah.
This one is a true or false. After a final adjudication of an action for separation by the Supreme Court denying support, the family court may not entertain a petition for support of such spouse.
True?
It's false. The family court.
I think I just made a question on this too.
The family court may entertain the application if it appears the petitioner is likely to become a public charge.
Oh, God. This question you already did, but I'll just read it. Unless the parties have specifically opted out of the following provisions.
Oh, good. I have a question on this.
in a validly executed agreement or stipulation. Oh, I have to change that. It says of stipulation. Or stipulation entered in between the parties, the court may modify an order of child support where A, blank years have passed since the order was entered, last modified, or adjusted.
3.
That's where I got the 3 years before, remember?
Yeah.
What was the 3 years before?
The other 3 years, there's one about the support magistrate has to be admitted to practice law for at least 3 years.
But then there was another one.
There was another 3 years. I don't remember what it was, though.
You did tell me something with 3 years. Okay, anyway. So 3 years have passed since the order was adjusted, or there has been a change in either party's gross income by blank
15%.
Yep.
Okay.
I didn't know that, and I just made the question. I had to look at
I actually knew that from work. I didn't know that from here.
Okay, actually, I think the next question you did. Upon a finding by the court that the respondent has willfully failed to obey any lawful order of support, the court shall or may order the respondent to pay counsel fees to the petitioner's attorney.
I'm going to say shall.
Yes. Shall or may commit the respondent to jail for a term not to exceed how many days?
I thought it was 6 months.
It's 6 months. I try to trick you.
Oh, okay.
And is it a shall or a may?
And it's a may.
Yes. Shall or may require the respondent to participate in a rehabilitation program.
That's a may.
And shall or may play the respondent on probation.
That's a may.
Okay, good. And then I have a 2011 question. The penalty for willful failure to comply with the family court order of support is punishment for contempt of court, and the respondent may be committed to jail for a period not to exceed
6 months.
Perfect.
All right, so this one's still on my phone, so I got to get it off my phone. Sorry. This is a different one. A reduction in income shall not be considered as a ground for modification unless it was blank and the party has made blank.
Unless it was... What are you looking for there?
Well, I'll give you... The first one is involuntary.
Okay.
And the party has made what?
A stipulation?
It's efforts to secure employment. And that he's trying to make the same amount of money he was before. 453. A petition for a violation of an order of support containing an allegation respondent failed to obey may be originated and prosecuted by A, the original petitioner,
Yes.
B, the support collection unit on behalf of persons in receipt of public assistance.
Yes.
The support collection unit on behalf of persons in receipt of services pursuant to 111-G Social Services Law.
Yes.
Yup. D, any person to whom the order is expressly payable.
I guess yes.
Yup. And then they're all true. Any person who may originate proceedings under Article 422 of this article. True or false, a respondent who appears in court charged with willfully failing to obey a lawful order of support is entitled to assigned counsel if indigent.
Wait, say that again.
A respondent who appears in court charged with willfully failing to obey a lawful order of support is entitled to a free lawyer if indigent.
I'm gonna just say no.
He is, because he could go to jail.
You're kidding.
Yeah, because he could go to jail.
Oh, so anybody that can go to jail gets a lawyer.
Yeah, if they could go to jail, they get a lawyer.
Good question.
Yeah. Okay. This is my last question, and we're done with mine.
Okay.
Before a court can make a finding of a failure to obey a lawful order of support, the court must A. Refer them. I'm just gonna read all of them, and you tell me which ones you think were good.
Okay.
A. Refer the matter to a support magistrate.
Yes.
B. No. B. Enter a money judgment.
Yes.
Yes. C. Be satisfied by competent proof the respondent failed to obey the order.
Yes.
And D. Hold a hearing.
Yes.
Yup.
All but the first one.
All but the first one.
Read the question again.
The court, before the court can make a finding of a failure to pay the support, the court, they have to hold a hearing, enter a money judgment, and be satisfied by competent proof respondent failed to obey the order.
Okay. Why are they going to enter a money judgment? But they're not going to get their money out of the bastard.
I don't know, but it just says that.
All right. Was that your last question?
That was my last one.
I think I only have like 2 or 3 more questions myself. We did good, man. We start on 5 tomorrow.
I know. I'm so tired. I can't wait to go to
The
bed.
respondent has accumulated support arrears equivalent to or greater than the amount of the support due pursuant to the order for a period of blank. The court may order the Department of Motor Vehicles to suspend his license.
I think this is the 4 months, right?
Yup.
Okay.
Any order of the family court requiring child support of a child terminates when blank makes an order in an action for divorce, separation, and annulment, providing for the child support of the child, unless the Supreme Court continues the order of the family court.
Is that like a true or false?
No, it's any order of the family court requiring child support of a child terminates when who makes an order in an action for divorce, separation, or annulment.
A Supreme Court justice?
The Supreme Court.
Okay.
Okay, and then the last 3 questions of the last 4 questions of the short ones that I just added with you, which were combined parental income shall mean the sum of the income of both parents. True. Any order of child support only shall include a provision for health insurance benefits.
True.
A certificate of warrant expires in
90 days.
The court magistrate's term is
5 years.
Court magistrates must be attorneys for at least
3 years.
Okay.
Yay, we did it!
Email myself now and print it tomorrow.
Okay, and I'll try to edit the video and get it up by tomorrow.
I'm going to hold on one second. Hold on, I'm going to mail it to myself. Do you want me to send you a copy of it again? Because the 2 you have the mistakes and not the added questions.
Yeah.
I'll send you the amended copy.
Okay.
Don't print the other 2, because I think I sent it to you twice by accident.
Okay.
So just put the family court questions 1, the one that says amended. And
Okay.
I also sent you a copy of the 3, and it says amended. These are the good ones. I have to make the fucking what's going on? I have to make the answer key now.
Okay. This was a lot easier than JD, though. I feel like I need to go over JD again.
Yeah, well, I will go over it whenever you want to. I mean, right
Yeah.
now. It's
Let's try to get through 5 tomorrow, and then we'll worry about doing JD again.
okay.
Okay, because 5
All right.
hopefully be as easy as this one
I'm going to
was.
stay up and print my answer key now so I can feel like I'm passing this board.
All right, I'm exhausted.
Okay,
I'm gonna
tomorrow,
pass
wait, what
out.
did you say about tomorrow?
What?
Go over JD, you said?
No, we're gonna try to get through 5. We're gonna try to make questions.
Is 5 a big article?
I don't think so.
Wait, do you have the announcement? Is it 5, 5A, 5B? Like, I don't know how big is 5.
I don't think it's that big, and I don't think we have 5A.
Okay.
We might have 5B, but we could just do regular 5 tomorrow.
Okay.
Okay?
I'll just do regular 5 tomorrow.
All right.
Hopefully I'll get through it.
All right. Good luck.
Tomorrow, we did good tonight.
All right. Good night.